All right, so we have a trial date scheduled for August 25th at 9 a.m. Have you submitted jury instructions and proposed voir dire questions?
No, I have not. I will do that tomorrow, Judge.
All right, Mr. Fleming.
I am looking right now, Judge. It is Miss Mears' file, just reviewing the notes that she has. Looks like we requested the subpoenas from MSP. They went out a few days ago. They should be fine. And as far as jury instructions, it looks like we submitted our proposed jury instructions back on July 19th, or excuse me, July 18th.
All right, are there any issues we need to address before we reach the trial date?
I have none, Judge.
I don't believe we have any either, Judge. I would just note that we did submit the amended complaint back on July 14th, changing count 2 to RNC of a motor vehicle. But that about covers it. People are ready to proceed, Judge.
All right, is there an offer from the people at this time, Mr. Fleming?
The notes I have show an offer of about almost a year ago of a joyriding, but I'm not sure if that would be accurate now that.
Yeah, there has been an offer made on this particular case. If Mr. Parker would enter a plea on this matter, the offer was that the recommendation would be that he receive no additional jail time. He received 5 costs and probation for this charge. He has rejected that offer. And he did that 2 days ago.
Your Honor, just for the court's record.
All right, one second, Mr. Daly, Mr. Parker wants to address the court directly. Do you have any issue with that?
No, Your Honor.
Go ahead.
I got employment now. I'm actually a work for Dawes Trucking Lansing full time. Working on semis, just. Yeah, but with Pelham's too, auto grenadiers.
Sorry, Mr. Fleming, what was count 2 amended to? I can't seem to find the amended information.
It was an RNC of a motor vehicle as opposed to RNC 1,000 to 20,000. Looks like we submitted, as I said, on July 14th.
Mr. Daly, do you have that?
I do, Your Honor. Matter of fact, I believe we have stipulated to the jury instructions.
All right.
I don't see that stipulation right here, but I told Ms. Myers I was going to. We have no problems with the instructions that she submitted.
All right, we will proceed to trial then on August 25th. Anything else we need to address today?
None for the people. Thank you, Judge.
No, Your Honor.
Thank you, Mr. Parker. You need to be back on the 25th at 9 a.m., obviously in person.
Brian.
Mr. Ragland, would you come forward to the podium? Okay, we are on the record in file 22-20686-FH, People versus Kyle Ragland. We are here today for a pretrial conference on a probation violation. We are proceeding today by video conference and in person. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Underwood.
Ron Underwood for Mr. Ragland this morning, Your Honor. Thank you.
I'm sorry, Ms. Fleming, appearing on this one as well.
Yes, Judge. Chris, I'm going to pre-amp of the people.
Thank you. And Mr. Ragland is present in the courtroom in person. Ms. Underwood, where do we stand with this case today?
Your Honor, we still have not gotten a definitive word on charges in this matter. So I would request a 2-week adjournment to see if anything comes of that, Your Honor. I do think Mr. Ragland is out on bond, Your Honor. He is remaining in contact very well with his attorney and communicating with us. And I think a 2-week adjournment in this matter would be appropriate.
Any issue with that, Mr. Fleming?
No, I would just make sure that Ms. Holly doesn't have any objection.
Ms. Holly, any issue with a 2-week adjournment?
No, I was wondering if are you reporting to Miss Monahan still, or he should
I
report?
go see her. I go see her on the 8th. Miss Holly.
Okay,
She's on vacation right now.
okay,
All right, so we'll set it out 2 weeks to August 16th at 8:15 a.m.
Your Honor, I'd like to let the court reflect the information, please.
One second, sir. Ms. Underwood, Mr. Ragland would like to address the court directly. Do you have any issue with that?
Kyle, is this a scheduling thing?
No, it has to deal with possibly getting a different lawyer. I'm in the process of possibly hiring another lawyer.
Okay.
So I'm just letting the court reflect that I go see another lawyer on the 8th.
Okay, so if you hire an attorney yourself, that attorney will know what to do. They just
Okay.
need to file an appearance and that will make the switch on that.
Okay. I just wanted to let the court reflect that possibility may be changing in the case.
All right.
All right.
And
So
what date is that, Your Honor?
August 16th
Thank you.
at 8:15. And Mr.
Thank
Ragland, you can attend that either in person as you did today or by Zoom.
Okay.
The
Thank
bailiff will hand you the Zoom information.
Okay. Thank you.
Ms. Underwood, Jonathan Betts is here in person. Do you need a breakout with Mr. Betts?
Just briefly, Your Honor. Thank you.
Mr. Betts, if you'll step to the hallway, there's an iPad out there and I'll put you in a breakout session with Ms. Underwood. Can you call Jill for actually? Okay, just 1 second here, Mr. Betts.
It's Kelly, Judge Sanders. Could we have Ashley Bean in the room, Judge, please? You. Bye.
All right, Mr. Vincent, there you are.
Good morning, Your Honor.
Okay, we are on the record in file 23-21413-FH, People versus Erica Hazinga Higgins. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. McCready.
Good morning, Your Honor. Dave McCready for the people.
Your Honor, Michael Vincent on behalf of Ms. Huizinga Higgins, who's present in my conference room. Say good morning to the judge. Then
Good morning,
state your name.
Erica Huizinga Higgins.
Okay, Mr. Vincent, where do we stand with Ms. Huizinga Higgins' case today?
We're prepared to enter a plea on this matter. We have, I think, worked out all the details of it.
All right, why don't you state for the record what the plea agreement is, and then I'll ask Mr. McCready to confirm.
Yes. Ms. Huizinga is going to plead guilty to possession of cocaine, a 4-year felony. The prosecutor's office, Mr. Sneed, said he would not object to excuse me, MCL 333.7411, which allows a person to plead guilty to a drug charge, and the charge will be dismissed upon successful completion of probation. Also, Mr. Sneed and I have worked this out that he would not object to no upfront jail. The firearms confiscated in the raid will be forfeited with the exception of a Beretta handgun that is a family heirloom. All other charges will be dismissed. I believe that 7 counts will be dismissed.
All right, Mr. McCready, is that a complete and accurate statement of the plea agreement?
Yes, with the clarification that we filed an amended information adding count 8, which is the possession of cocaine that she'll be pleading to. So we're adding count 8, and then we would be dismissing the remainder of the charges.
Absolutely no objection to that.
All right. Mr. McCready, when was that amended information filed, or I guess more importantly, can you email a copy of that to me?
I should be able to do that, yes. I'm not sure when it was filed, but let me see if I can get a copy to you right now.
Okay.
We don't have a copy. So, I don't believe we have a copy also, Your Honor. Still have your photos in the file. I took a look at it. Oh.
All right, I have a Lenawee County jail device logged in. I'm going to need someone to turn on the video and unmute the microphone there at the Lenawee County Jail if there's anyone in that room.
Got it.
So I'm getting ready to send this email. Can you guys tell me what the email addresses you'd like them sent to?
1 second, Mr. McCready, I will send that to you in the chat.
Okay.
Okay, Mr. Murphy, I believe we have Ms. Beam here. Do you need a breakout session with her?
Yes, please, Your Honor.
Ms. Hennigan, what case are you here for?
Carly Frank, Your Honor.
All right. While I'm waiting for that amended information to arrive, let's move to Ms. Frank's case.
I'm sorry, Your Honor. Could you put me back in for a second?
Yes. All right, we're on the record now in file 23-21418-FH, People versus Carly Lynn Frank. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Fleming.
Chris, let me appear on behalf of the people.
Maris Hennigan on behalf of Ms. Frank.
And Ms. Hennigan, where do we stand with Ms. Frank's case today?
Your Honor, this is our first pretrial. It's a rather intricate case, and I don't have an offer from prosecution yet, likely due to their worst getting discovery, exchange, etc. So if we could just set this for another pretrial.
Ms. Hennigan, your audio was bad. I don't know what happened there, but I was not able to understand what you said.
I apologize. Can you hear me now, Your Honor?
That's better, yes.
Thank you. This is a rather intricate case that has a lot of moving parts and co-defendants. Prosecution's not given an offer yet for my client to consider. So I would just ask that we set this for another pretrial.
All right, Mr. Fleming, anything that we need to address from the people's side?
I don't believe so. I think that covers it. People have no objection to an adjournment of the pretrial.
Just
How about September 20th at 8:15 a.m.?
Works for the people. Thank you, Judge.
We will make that work, Your Honor. Thank you.
All right, Ms. Hennigan, would you be willing to prepare stipulation in order for that adjournment?
Yes, Mr. Fleming, may I sign with your consent?
Absolutely. Thank you, Ms. Hennigan.
Thank you.
Thank you. All right, so Ms. Frank, you can go ahead and log out. You're all set for today. Your next date is September 20th at 8:15 a.m. You'll use all the same Zoom information to log in on that date.
Okay, thank you, Your Honor.
You came from Wayne County, right? No different than Wayne County?
All right, I have the amended information now for Ms. Huizinga Higgins, so we can turn to that case. All right, so Mr. Vincent, I'll need you to have Ms. Huizinga Higgins be in front of the camera so I can see her. All right, Ms. Huizinga Higgins, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. And you are Erica Hazel Michelle Huizinga Higgins?
Yes.
Ms. Huizinga Higgins, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention today to plead guilty to count 8 on the amended information, which is controlled substance, possession of cocaine, heroin, or another narcotic of less than 25 grams?
Yes, Your Honor.
Are you satisfied with Mr. Vincent and the advice that he's given you?
Absolutely.
Do you understand that the maximum penalty for that offense is up to 4 years in prison and or a $25,000 fine?
I do.
Other than, as we've discussed on the record here today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. McCready?
Yes, it is, Your Honor.
Mr. Vincent?
It is our understanding there will be no upfront jail. And for want of a better term, I kind of understood this to be a killaboo plea. But that's part of the plea that we agreed with.
All right, my understanding of what was said earlier was that the prosecution would have no objection to no upfront jail.
Yes,
That would be different than a killaboo agreement to no upfront jail. So, Mr. McCready, is that the people's agreement?
Yes, it's an agreement that there would be no upfront jail.
Okay. All right, so other than, as we've now discussed and clarified on the record today, Mr. Vincent, do you agree that no one has discussed a possible sentence with court other than what we discussed on the record today?
yes, that there will be no upfront jail. I agree with that, Your Honor.
Okay, that's not the question I asked, Mr. Vincent. What I'm asking is, other than as we've discussed on the record here this morning, do you agree that neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court?
I'm sorry, I misunderstood you. I do agree to that.
Okay, is that also your understanding, Ms. Huizinga Higgins?
It is.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Ms. Huizinga Higgins, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
I do not.
Do you understand that you're giving those rights up?
I do.
How do you wish to plead to the charge that on or about May 19, 2023, in the village of Clinton, Lenawee County, Michigan, that you did commit the offense of possession of a controlled substance, cocaine, heroin, or another narcotic of less than 25 grams.
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you will be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the board on the record this morning, or that it was not your own choice to enter the plea?
I do.
The prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Huizinga Higgins to plead guilty?
None, Your Honor.
Mr. McCready, if you responded, I did not hear you.
I said no.
Okay, thank you. Ms. Huizinga Higgins, has your attorney promised you any particular sentence or estimated what your sentence would be, other than as we've discussed it on the record this morning?
No, he is not.
Is it your own choice to plead guilty today?
It is.
Mr. Vincent, do you want to establish a factual basis?
Ms. Huizinga, on May
19.
On May 19th, did you possess cocaine, a very small amount?
I did.
Are you a medical doctor? Did you have a prescription for that?
No, I did not.
And it was an illegal substance you possessed,
Yes, it was.
and it was cocaine.
Yes, it was.
Mr. McCready, any follow-up?
No, the people are satisfied with the factual basis.
Ms. Huizinga Higgins, were you located in the village of Clinton when you possessed that cocaine?
I was.
And did you have any prescription or other legal right to be in possession of that cocaine?
I did not.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. McCready?
Yes, it has.
Mr. Vincent?
Yes, Your Honor.
Okay. Accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Huizinga Higgins has had full knowledge of her rights and she's had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation. And we'll set sentencing for September 15th at 8:15 a.m. unless there's an issue with that.
Your Honor, would that be in person or by Zoom?
Ms. Huizinga Higgins has a right to be in person in the courtroom. If she wants to do that, she would need to waive her right to do that if she wanted to be sentenced by Zoom, which I'm perfectly willing to do.
Thank you, Your Honor. You wanted to?
I will wait. I will waive the in-person.
Okay.
And Judge,
So-
Erica has been doing twice weekly drug screens and they've always come back clean. She's doing a good job at that.
Okay, thank you, Mr. Ghost.
And Your Honor, one further, she's been on the GPS tether during the duration of this proceedings and the proceedings prior to that. We would ask for that GPS tether to be removed now. And I
Sure,
appreciate what probation said.
Mr. McCready, do you have any response to the request to remove the GPS tether?
We would have no objection to that, Your Honor.
Thank you.
So I'll modify the bond conditions to remove the GPS tether condition so that can be removed.
Erica, what I'm going to do is I'm going to go ahead and send an email over to JSG to Don. So if you want to go ahead and return that, you could go ahead and do that.
Thank you, Darren. I appreciate it.
Okay, it also, sorry, never mind. We do have fingerprints, so we are all set for sentencing. So September 15th at 8:15 a.m., you'll use all the same Zoom information that you used to log in today.
I
Thank
need
you,
an
Your Honor.
address.
Oh, I'm sorry. I'm going to put you, Mr. Vincent, Ms. Huizinga Higgins, I'm going to put you in a breakout session with Ms. Holly from the probation department so that she can collect your contact information. If you give me just a moment. Okay, Mr. Murphy, are you ready to proceed with Ms. Bean's case?
Yes, Your Honor.
Okay, we're on the record then, file 23-21399-FH, People versus Ashley Nicole Bean. We are here today for a pretrial conference, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Fleming.
Chris Fleming, appearing on behalf of the people.
Matthew Murphy, appearing on behalf of Ms. Bean.
All right, Mr. Murphy, where do we stand with Ms. Bean's case today?
Yes, Your Honor. From my understanding, the offer from the prosecution is for Ms. Bean to plead to possession of methamphetamine, a first offense notice. She is charged with a second offense notice, and that the police officer assaulting, resisting, obstructing would be dismissed along with a habitual offender notice. If that is correct, she does wish to accept that offer today. It is with entry from the drug court. I'm sorry.
I'm sorry, what was the last part, Mr. Fleming? Mr. Murphy?
That was with entrance into drug court. She's already been accepted into drug court.
Okay. Mr. Fleming, is that a complete and accurate statement of plea agreement?
I believe so, as possession of meth. Dismiss the rest.
All right, so possession of methamphetamine with the first. All right, Ms. Bean, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
You are Ashley Nicole Bean.
Yep.
Ms. Bean, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, possession of methamphetamine or ecstasy?
Yes. Yes, sir.
Are you satisfied with Mr. Murphy and the advice that he's given you?
Yes, sir.
Do you understand that the maximum penalty for that offense is up to 10 years in prison?
Yes.
Either the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed on the record here today. Is that correct, Mr. Fleming?
That's correct, Judge.
Mr. Murphy?
Yes, Your Honor.
Is that also your understanding, Ms. Bean?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Ms. Beam, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about April 15, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of possession of methamphetamine or ecstasy?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Bean to plead guilty?
No, Your Honor.
No, Your Honor.
Ms. Beam, other than as we've discussed on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
Just rehab.
So you
Your Honor, I
understand,
informed Ms. Beam that she has been accepted in a drug court with a stipulation that she has to be entered into rehab prior to any release of incarceration. So she will be looking at rehab before she goes anywhere from the jail.
okay, do you understand that, Ms. Bean?
Yes,
And you still want to move forward with entering your plea?
yes,
All right, is it your own choice to plead guilty today?
yes.
Sir Murphy, would you like to establish the factual basis?
Yes, Your Honor, thank you. Ms. Beam, were you indeed in the city of Adrian, county of Lenawee, state of Michigan on April 15, 2023?
What is it?
Were you in the city of Adrian in the county of Lenawee, the state of Michigan on April 15th of this year?
I can't understand because the speaker's like broke.
I'll try to talk slowly. Were you in the city of Adrian on April 15th of this year?
Yes, sorry.
And would you agree that the city of Adrian is in the county of Lenawee in the state of Michigan?
Yes,
Okay. And on that date, did you have in your possession methamphetamine?
yes,
And you knew that that was methamphetamine that you had in your possession?
yes,
And you did not have any legal reason to possess that methamphetamine, is that correct?
no,
Okay. Your Honor, I'm satisfied with the factual basis.
Mr. Fleming,
Keyboard satisfied, Judge.
has the court complied with MCR 6.302 B, C, and D, Mr. Fleming?
Yes, Judge.
Mr. Murphy?
Yes, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Ms. Beam has had full knowledge of her rights. She's had competent counsel. I will refer this matter to the probation department for pre-sentence investigation and set sentencing for September 21st at 8:15 a.m. Ms. Beam, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
okay,
We will continue bonds as currently set. So we will be back for sentencing on September 21st.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
Thank you,
And just to
Mr.
confirm,
Murphy.
Judge, I know Mr. Murphy was asking about Miss Beam being released to inpatient directly from the jail. I believe that was done on June 28th. I just want to confirm that was done. I apologize.
so does that mean I can go to rehab?
Yes, Ms. Beam, what we're trying to establish is if you're releasable, because right now you're being held on the bond, so the judge has to say it's okay for you to be released from the jail to rehab. And we're trying to confirm if that's the case already, or if not, if the judge is willing to change the bond for that.
Okay,
Yes, there is a pretrial release order in the file that dated or filed June 28th this year that indicates defendant may be released directly to an inpatient residential drug treatment facility and must enter and complete the program.
Thank you, Your Honor. Thank you, Mr. Fleming, for clarifying.
Thank
So
you, Judge.
that's gonna happen before sentencing?
I don't know if it will. It depends on if they can find her a spot, I guess.
Because she's gonna have to do the interview. They're gonna still have to do a PSI. I just want to make sure she's still available.
So obviously, Mr. Murphy, if she is released, someone's going to need to communicate that information to the probation department so that they can do their PSI.
Yes, Your Honor.
Okay.
All right, Ms. Beam, you are done for today. You can let the officer know that you are finished with court for now.
okay, thank you.
Thank you.
Ms. Underwood, are you ready to proceed with Mr. Betts?
Yes, Your Honor, thank you.
All right, Mr. Betts, can you come forward to the podium, please? Okay, we're on the record in file 21-20216-FH People versus Jonathan William Betts. We are here today for a hearing on a probation violation, alleged probation violation. We are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Betts this morning, Your Honor.
All right, and sir, you are Jonathan William Betts.
Yes, sir.
Mr. Betts is here in the courtroom in person. Ms. Underwood, where do we stand with Mr. Betts's case today?
Mr. Betts has completed, Your Honor, his court in Monroe. Mr. Betts at that time pled to a domestic violence, Your Honor, which I believe is the genesis of this probation violation. So he would plead to same here.
All right, Mr. Betts, would you raise your hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
And you are Jonathan William Betts.
Yes, Your Honor.
Mr. Betts, do you understand that you have a right to contest this violation of probation charge and to have a trial on it?
Yeah.
You understand that throughout that trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence.
Yes, sir.
You have a right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions while they're under oath at your trial. And you also have the right to have me order any witnesses that you have for your defense to appear at your trial. You understand all of that?
Yes, sir.
You do not have to testify at your trial, and no one can say anything about you not testifying and hold that against you in any way. Do you understand that?
Yes, sir.
On the other hand, you also have the right to testify at your trial if you wanted to testify. Do you understand that as well?
Yes, sir.
How do you plead to the charge that you violated your probation?
What does she want me to do? Do I plead guilty to that?
I'm sorry, I can't hear. Mr.
Do I
Betts.
plead guilty to that or not?
I believe we agreed, or you wanted to plead guilty to that, Mr. Betts.
Yeah, I'll take the plea. Yeah.
Okay. So how do you plead to the charge that you violated your probation? Sorry?
Guilty.
Has anyone promised you anything in order to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way in order to get you to plead guilty?
No.
You understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've explained to you today.
Yes.
If I accept your plea, you'll be giving up any and all claims that the plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. You understand that?
Yeah.
Is it your own choice to plead guilty today?
Yes.
You were placed on probation in this case back in August of 2022. Is that correct?
Yes.
And I'm looking at actually the original order of probation that appears to have a signature on the defendant's signature line. Did you receive and sign a copy of this order of probation?
Yeah, I'm sure I had it.
One of the terms of your probation is that you're not engaged in any assaultive, threatening, or intimidating behavior. Is that correct?
Yeah.
And on January 28, 2023, did you have an interaction with a Julie Fox that resulted in charges being made against you in Monroe County?
Yeah, I call it domestic.
And you pled guilty to something in Monroe County as a result of that incident?
Yeah.
What is it that you pled guilty
I
to?
pled for domestic violence.
You pled guilty to domestic
Yeah,
violence?
with DD.
All right. I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Betts has had full knowledge of his rights and he's had competent counsel. I will refer this matter to the probation department for an update of your pre-sentence investigation. And I'll set sentencing for September 21st at 8:15 a.m.
Judge, we also have a warrant for him for bond condition violation where he is out on a GPS tether, and that tether was turned off on July 25th due to non-payment. I also do not have a working telephone number to the defendant.
Your Honor, I believe Mr. Betts, that was a misunderstanding on Mr. Betts's part. He thought when the case in Monroe was over, he didn't need the tether anymore, Your Honor, so he didn't pay it. He's prepared to pay the backlog on the tether, Your Honor. Mr. Betts is not under any bond conditions in Monroe County anymore, Your Honor. I believe he's completed everything, including jail there. Mr. Betts has always been communicative, both with myself and he's appeared in court. I would ask that his bond be continued, and if the court wants to continue the tether, he will pay the what he owes and pay for new tether costs as soon as next week.
All right, Mr. Betts, can you pay, do you have the ability to pay to get the tether turned back on?
I can pay what I owe on it. Next week I can get it turned on. Does that work? I would ask if there's any way like I could get it taken off if I paid it, because I don't have a no contact order anymore. Like I'll make it to court. I mean, I could pay it. If I had to pay it today, I mean I could, but like I just bought a car and I don't get paid like until next week, and I really don't want to ask my parents for money right now.
All right, so what I'm going to do is I will recall that warrant on the condition that you
I can pay it next Friday.
pay to get it turned on by Friday, August 11th.
Thank you, Your Honor. And I believe Mr. Betts is there and he can provide Mr. Coast with his phone number, Your Honor.
Mr. Betts, if it's not turned on by Friday, the 11th, I'm going to issue another warrant. We'll be
Okay.
back where we are.
I'll have it paid next Friday, I promise.
I want you to know where things stand.
Okay, do you want me to pay the back pay on that, like the 3 days? I could probably pay that, or I could just pay it
Yeah, you've got to talk to
Friday.
you've got to talk to the tethered company and
Okay.
work that out with them.
Okay,
All I'm saying is it's got to be turned on by next Friday.
Friday, I got you.
Right? So if you'll step back to the hallway, I will put you in a breakout session with Mr. Coast and Ms. Holly so that you can give them the contact information.
All right, thank you.
Can we get Alexa for the judge, please? Thank you.
Mr. Murphy, is there Mr. Rudnicki in the courtroom? Mr. Rudnicki, okay. Mr. Murphy, you need a breakout session with Mr. Rudnicki?
Yes, Your Honor.
Right, so Mr. Rudnicki, if you'll just wait for a moment until our iPad is not in use and then step into the hallway, I'll put you in a breakout session with Mr. Murphy. Dagger Margosian, you ready to proceed with Mr. Schneider?
Yes.
Mr. Fleming, is that one that you can handle?
Yes, Judge.
Okay. All right, we are on the record in file 23-21346-FH, People versus Eric Charles Schneider. We are here today for a pretrial conference, and we're proceeding today partially in person and partially by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Fleming.
Chris Fleming, appearing on behalf of the people.
Your Honor, good morning. Michael Dagmar goes in for Mr. Schneider.
And sir, you are Eric Charles Schneider?
Yes.
All right, so for the record, Mr. Fleming's here by video conference, Mr. Dagmar-Margosian and Mr. Schneider are here in person. Mr. Dagmar-Margosian, where do we stand with Mr. Schneider's case today?
Your Honor, we have reached a resolution with the people. The proposed plea would be that Mr. Schneider pleads guilty to counts 2 and 3, and in exchange, counts 1 and 4 will be dismissed. And we are prepared to enter that plea today.
All right, so that's a plea to counts 2 and 3, counts 1 and 4 being dismissed. Is that a complete and accurate statement of the plea agreement, Mr. Fleming?
It is, Your Honor.
All right, Mr. Schneider, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Eric Charles Schneider.
Yes.
Mr. Schneider, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, using a computer to commit a crime, maximum imprisonment of 4 years or more, but less than 10 years?
Yes.
Is it also your intention to plead guilty today to accosting children for immoral purposes?
Yes.
Understand that the maximum penalty for that offense is up to 4 years in prison and or a $4,000 fine.
Yes.
Are you satisfied with Mr. Dagmar-Margosian and the advice that he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Fleming?
That's correct, Judge.
Mr. Dagmar-Margosian?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial. If the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial. You have the witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Schneider, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
You understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about April 4, 2023 in Madison Township, Lenawee County, Michigan, that you did commit the offense of using a computer to commit a crime, maximum imprisonment of 4 years or more, but less than 10 years?
Yep.
How do you plead to the charge that on or about April 4, 2023 in Madison Township, Lenawee County, Michigan, you did commit the offense of accosting children for immoral purposes?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
I need you to speak up a little bit.
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Schneider to plead guilty?
No. No,
No, Your Honor.
Mr. Schneider, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
Mr. Dagger Margosian, do you want to establish the factual basis?
Mr. Schneider, I know the complaint says April 4th, the affidavit says April 6th, so either on April 4th or April 6th, did you use your phone to use an application called Skip the Games?
Yes.
And Skip the Game is, I guess for lack of a better term, a dating app or a romantic app?
Yes.
Okay. And did you use that app to try to find somebody to have sexual relations with?
Yes.
Okay. Did you have a conversation with an individual that you believed to be 15 years of age?
Yes.
Okay. And in that conversation, was it established that you would go to a particular address to have sexual relations with that individual who you believe to be 15 years old?
Yes.
Okay, and did you go to that location?
Yes.
Okay. And your intention your intention on going to that location was to have sexual relations with that person?
Yes.
Okay. And again, you had used your phone to set that up, yes?
Yes.
Okay, and you'd agree that the phone, for purposes of this crime, is considered a computer device?
Yes.
Okay. You're not, I think I'm satisfied.
All right, Mr. Fleming, are the people satisfied?
People are satisfied.
Has the court complied with MCR 6.302 B, C, and D, Mr. Fleming?
Yes, Judge.
Mr. Dagger Mangosi?
Yes, Your Honor.
I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Schneider has had full knowledge of his rights and competent counsel. Court's not made any agreement regarding the possibility of a plea or possible sentence in the case with the prosecuting attorney, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for September 21st at 8:15 a.m.
Thank you, Judge.
Bond will be continued as it's currently set.
I wanted to make sure I didn't miss anything on jail. Was there any agreement on jail or anything?
There was not beyond pleaded to count 2 and 3, dismiss counts 1 and 4.
Okay, thank you.
All right, I'm going to stop.